All right, we are live here on YouTube. This is the Common Thread, a production of the Law Office of Andrew P. Gross, where we talk to veterans, people who are veteran adjacent, people who are working in the with veterans in the field, and talking about how our lives intersect. And again, the common thread being that we're all somehow tied to the military and what have you. Today, I have a conversation. I'm having a conversation with attorney Rob Jenner. Rob is a longtime personal injury attorney. He's not a veteran himself, but comes from a military family. He has represented injured individuals for a number of years in cases large and small, a lot of federal court work. Previously was doing, I believe you were doing the 3M earplugs is the one that is probably many of our listeners will be familiar with, but also medical malpractice and Federal Tort Claims Act cases against the U.S. government for injuries to individuals.
That's right.
I wanted to bring him on today to discuss something that, if you're online, you're on social media, you're probably seeing this and being inundated with ads for the Camp Lejeune Justice Act and lawsuits that you can file against the government for poisoning of the water at Camp Lejeune, or Camp Lejeune, as I was once corrected by a Marine. It's apparently, much like, the French language, spelled and pronounced two different ways. But anyway, thanks Rob for coming on.
Well, thanks for having me. I appreciate it.
Can you tell the listeners and viewers and folks who are probably stuck in traffic listening to this, who don't have the luxury of working from home, a little bit about yourself and your practice?
Sure. Again, thank you. I've been practicing personal injury law on behalf of consumers for over 37 years, mostly in the space dedicated to people who've been hurt by toxic chemicals, toxic exposure, environmental carcinogens, medical devices, pharmaceutical drugs. That's principally what I've been doing for my entire career.
And how long has your career been?
Well, 37 years. So it's been a long time representing plaintiffs.
So you have a little bit of experience under your belt. You've seen a thing or two in the setting, right?
A thing or two or three, actually. Yes.
Yeah. Right. So there's no substitute for experience in this practice. Although with trial work, personally, what I learned with experience was it's very difficult to expect what's coming next sometimes.
Yeah, it's your schedule and your calendar are not your own. And judges do what judges do, and juries do what juries do, and all we can do is be as prepared as we can possibly be and fight hard.
Yeah, that's definitely true. It's funny you say what juries do and what judges do. The case I want to talk about today, rather the case I want to talk about today, I don't think there are going to be very many juries in these, are there? And that's the Camp Lejeune water poisoning case. Tell us what are those about.
All right. Well, Andy, you've been former JAG Corps, so you're going to know about this intimately. Camp Lejeune is a military base that began in 1942 in Jacksonville, North Carolina. About 10 years later or so, about 1953, they started recognizing that the water in the camp was contaminated with toxins, contaminated with poisons, volatile chemicals. And from 1953 to about 1981, those chemicals were there. The higher ups and the officials knew they were there and didn't do anything about it. And so people were being poisoned and developing all sorts of carcinogens and diseases. And in a nutshell, we are now able to make a claim for those injuries.
So, we're sitting here today in 2022. Why weren't we able to make claims for these injuries, 20, 30 years ago?
Right. So In the law, without getting too technical, there's something that are called statute of limitations and statutes of repose. And in a nutshell, what they do is they limit the time that you have to file a lawsuit. And in North Carolina, where this is, you have no more than 10 years after your first exposure to the chemicals to file a lawsuit. And these are diseases that you may not develop for 10, 20, 30, 40 years after exposure. And so people are now getting diseases, recognizing that it could be affiliated or caused by the toxins at Camp Lejeune. But there's nothing they can do about it, except now. And 2 weeks ago, President Biden signed the Camp Lejeune PACT Act, and that waived the statute of limitations and the statute of repose, which now give veterans the opportunity to go back and make claims for the next 2 years.
There is still a statute of limitations, though, right? With this, wasn't there? They can't wait on this. They have to jump on the claim pretty soon, correct?
They do, and quite frankly, time is of the essence. You have to move quickly. You have 2 years to begin the administrative process. So it hasn't erased it. It just sort of put it on. It sort of rebooted it, if you will, and then we can start all over. The statute started on the date that the act was signed, which was August 8th. And so we have 2 years from there.
So you have basically 1 year and 50 weeks left to file a claim. And these are prosecuted like Federal Tort Claims Act cases, right? So it's not just, you don't just file a lawsuit, right?
That's correct. Well, the first thing you have to do is you have to file a claim form, and we can help you fill that out. Thankfully, the form is not too complicated, but the claimant does need to sign it and get some information together and then file it as part of the administrative process. The government then has 6 months to process the claim, to look at it, evaluate it, see if they need more information. And at that point, the process begins. They can either deny your claim or they can accept it and make you an offer. If you like the offer, you can take it. If you don't like it, you can reject the offer and then file a lawsuit in federal court like you would any other Federal Tort Claims Act litigation.
And these cases are tried in front of a judge, not a jury. Is that right?
That's correct.
Okay. So now there is a little bit of distrust and weariness about these because, a lot of, at least as my clients and a lot of veterans out there may already be receiving VA daily compensation for various types of cancers that are linked to Camp Lejeune. How do these lawsuits impact that?
That's a good question. And a candid answer is we're not 100% sure yet because the process hasn't gone through. What we believe is going to happen is that if a person is already receiving benefits for exposure to Camp Lejeune toxins, then you can still make a recovery, but there may be an offset to what the person has received. If they've already received some portion of a recovery, that portion may be deducted. Whether that's a big portion or a small portion, we don't know yet. And I think people need to be candid about that. And that's where somebody like you comes in, Andy, who has a familiarity, with the statutes, can really help give guidance to somebody who's looking to understand what these offsets may mean. But it's a work in progress.
Yeah, and I think that it probably depends a lot on the individual cases too, because if you're 100% disabled, and perhaps, sadly might be terminally ill, a larger one-time payment may make more sense than continuing to get whatever your disability payment is going forward. And I think that it's as you said, it's super important for individuals to get that candid answer. Who is doing all this marketing out there? I know I've gotten some ads. General Law has popped up in my Facebook stream. And by the way, full disclosure, I'm a member of the Maryland Association for Justice. It's the plaintiff's lawyers bar. So is Rob. We are both Baltimore guys. and so that's how we know each other. But I do get your ads, but I'm seeing ads. I got one in the Penny Saver envelope the other day. I was thumbing through it, and in between ads for tree services and roofing services, I saw a Camp Lejeune flyer. Is this other law firms marketing for this?
Yes, other law firms are marketing, but there are also law firms who go out and hire marketing companies who are going out and doing it. And so the marketing companies could represent, 5, 10, a couple dozen different law firms, and then they just circulate it out and they just ferret them out, randomly. I don't do that. I'm not doing that here. Right now, I'm just, representing mostly people in the Washington metropolitan area, but also nationwide, as I do for all of my plaintiffs, but mostly in the Washington area, for people who come. I mean, look, there are law firms that represent, tens of thousands of people who were at Camp Lejeune. I'm not like that. I represent a smaller group of people. Individual service is what we're known for at our firm. I've been together with some of the folks in my firm now for 20 years plus. We have a smaller group, but we give everybody the individual attention they deserve, and that's really what we pride ourselves on.
So okay, so if a client calls the firm, they can eventually get through to a lawyer, right?
Absolutely. They can have my cell phone number and call me anytime. We are here to service the clients on an individual basis. You're not a number, you're not a factor, you're not a matter, you're not a case. We represent you, and we have a relationship with you, and that's how I've built my practice for the last 37 years, and that's what I'm going to do to continue.
That's good to hear. I know it can be tough. Keeping up, especially if you have a number of clients, you can spend a lot of time on the phone. But you're right. It is important to speak to your clients and let your clients know. Now we talked about veterans a lot.
Mhm.
The Camp Lejeune veterans, going to be a lot of Marines and probably Navy corpsmen. But what about, is there anybody else who can actually file these claims as well?
Yeah, right. So you don't have to be a veteran, Andy, in order to recover under the Act. You just need to have been exposed to the water for more than 30 days at Camp Lejeune. So you can be a contractor. You can be a private citizen who was working on base. You can be the spouse of a veteran. So it's really just the exposure to the water from 1953 to 1981, and that's the time period. And if you're exposed during that time, regardless of whether you're a veteran or not, you can recover under the Act.
I mean, that's a pretty big deal, right? Because up until now, it's only been veterans who've been getting VA disability, but now, the veteran might be taken care of, but the veteran might also have a wife and 2 kids that were there in 1970 something that now
That's
are
correct.
sick.
Yeah, I think I said 1981. I meant 1987. So you're right. Kids who have been affected, or if a woman that has infertility problems or stillbirths, or other problems with conception, those are things that may be recoverable under the Act, and those are things that we're looking for as if we can establish a causal relationship between the toxins and the injury. Yeah.
So what kind of diseases and injuries do you suspect may have been caused by this? And I mean, obviously not you probably have research and experts and oncologists and guys who do with millions of lines of data, but what kind of injuries are you, I don't say marketing for, but do you expect folks to call you with?
Sure. So some of the top ones are Parkinson's disease, kidney cancers, blood diseases, leukemias, liver cancer, bladder cancer, lymphomas. Those are the type of things that we're principally looking for. But there's also female infertility and other types of problems for conception that I think are huge cases, and huge injuries that families have suffered.
What about things like prostate cancer? Is that one of them, or is that?
It is ovarian cancer, prostate cancer, rectal cancer, brain cancer, um, male breast cancer, lung cancer. So we're looking at them all, and if we can, get an expert to look at the time period, the length of exposure, the type of exposure that they may have been that they may have suffered, and if an expert can put it together, that's what we're looking for. Andy, you said it. It's not what Rob Jenner thinks or what any lawyer thinks. Um, these are highly technical areas involving epidemiology and case-specific causation and case general causation, and a lot of areas of the law that intersect with science, and that's what we do.
Now, of course, we're seeing all these ads. Clearly, we wouldn't be seeing all these ads if there wasn't a lot of money to be made by lawyers and, I guess, marketers. How are lawyers going to get paid through all this? What's a case look like, and how do you make your money at the end of the day?
Right. So this is no different from any other personal injury case. As a lawyer who represents consumers, we work on what's called a contingency fee basis, which means that our recovery is contingent upon a recovery in the case. So at no point will any lawyer, or certainly not me, ask you for any money up front. We'll ask you to pay any costs, and hopefully should there be a loss, should there be no recovery, we're not going to ask that costs be reimbursed. And so it is literally an opportunity for a consumer to go forward with a case without risk. And that's a good thing, because otherwise people wouldn't be able to go forward in any type of case, an auto case, a medical negligence case, a therapy abuse case, whatever it is. You wouldn't be able to go forward if there was a financial risk. Average folks can't afford that. So we take a percentage of the recovery, and that percentage can range depending upon what the statute provides and what the limitations are. From, could be 40%, could be 25%. Right now, there is no cap in the act itself, and so it's not clear whether or not there's going to be an administrative cap on the recovery or not, and that's something that needs to be worked out. But we do take a percentage of the recovery, and that would be only in the event of a recovery at the end of the day.
Where are these cases going to be tried? If they're going to be tried, are they going to be all over the country, or is everything happening on the North Carolina beaches?
Yeah, in North Carolina, United States District Court for the District of North Carolina. One of the federal courts there will be the court that oversees this litigation. Usually when cases like this happen, there are individual cases with individual clients that are all consolidated before one judge, and that judge oversees the entirety of the litigation. Again, this is brand new, Andy. We're just getting underway. And so how this all shakes out, and who's on the leadership committees, and who are the lawyers that are going to be standing up in front of the judge is yet to be determined. But that being said, every client will have his or her own lawyer representing them, whether or not they're the ones actually standing up in court, or whether there's a management or an organizational or a plaintiff's leadership or steering committee that actually are the ones that are standing up on behalf of everybody.
So instead of having 400 plaintiffs' attorneys standing at a 3-person table, they'll nominate somebody to speak for them on administrative purposes, but the individual cases still rest with whoever your attorney is, right?
That's right. So usually in a mass tort, in a consolidation, there are different leadership structures that are set up, and there can be lead counsel, there can be a liaison counsel, there can be an executive committee, a plaintiff steering committee, all sorts of different committees that help run the case, if you will. At the end of the day, when the cases are tried, you have your own lawyer, and that lawyer will stand up for you and try your own case in the event that it needs to be tried. But the actual running and the organization of the discovery process, the portion of a lawsuit where documents are exchanged and depositions are taken, those are done usually by a management committee. So if we want to take the deposition, for example, of the person who is head of the base during a certain period of time, that person's deposition is taken one time. Not every single plaintiff gets to take that person's deposition. It's taken once for use by everybody. Who is that person who takes deposition? Those are the people who are part of the steering committees and the organizational committees usually that get that done.
Okay. It makes a lot of sense. So you're not asking the same person the same question 2,000 times
Right.
or more. So have
Right.
you found?
Think of it like a bus accident, right?
Yeah.
There are many people on a bus and the driver goes through a red light. You can take the bus driver's deposition once, but not everybody on the bus needs to take the bus driver's deposition. They don't need to ask them questions. They can just nominate one person to take the deposition for all the people on the bus. It's sort of like that.
It's not like the bus driver's answer is going to change
Exactly.
from the front of the bus to the back of the bus as you go through all the plaintiffs.
That's right.
That's really interesting. So have you filed so far any SF, was the SF standard form 95s yet? Have you filed any of those for?
They're not SF95s, or they call CLJA forms is what they're called. And I have them filled out. We just need to get them signed by our clients, and then we're gonna upload them. We want to get it done quickly, though. We do want to get it done quickly because once there are going to be a lot of people, and we want to get in line. And so, yes, we're gonna get those filed this week.
Great, that's exciting. That's exciting that things are already rolling and moving that quickly. So was the CLJ Camp Lejeune Justice Act, was this part of the larger PAC Act? Was it all part of the same bill?
It was. So the act itself, the Honoring Our Promise to Address Comprehensive Toxics Acts of 2022, known as the Honoring Our Pact Act of 2022, was an act of Congress which was intended to improve healthcare access for veterans who were exposed to toxic substances. The Camp Lejeune Justice Act of 2022, again, which was signed into law by President Biden on August 10th, was a provision of the PAC Act. And so it was for those people who were exposed to and injured by toxins at Camp Lejeune, and gave them benefits that they didn't have before.
Okay. So it was a pretty big piece of legislation, all told. I want to shift gears a little bit here. I mentioned in the intro that you had your hand in the 3M earplug cases, which is much more my generation. I mean, if you're talking 1952 to 1987 for Camp Lejeune, while some of those folks may have eventually served in the global war on terror, many were retiring by the early 2000s. But the 3M earplug cases, you deployed between a certain period of time, you got the little yellow and black earplugs. So how are those cases going? What's the latest on those?
Okay, well, this is also a mass tort. The cases are consolidated before Justice Casey Rogers down in Tampa, Florida, federal court. Pensacola federal court. There are approximately 220,000 claims, making it the largest mass tort ever in the history of litigation. This is the biggest mass tort case there's ever been. So all of these claims are filed before Judge Rogers now, or consolidated before Judge Rogers. She has had so far, I mean, this case has been masterfully handled by her. She had about 16 cases so far that were tried, and she had one on top of another, which is great for plaintiffs because we want to get to trial. And the more cases we get to trial, the better it is for the prospects of settling the entire litigation, so everybody has to get paid. I mean, let's face it, it cannot be that 220,000 people go to trial. So they tried 16. The results were terrific. I think we won certainly about 3/4 of them. Plaintiffs were successful for varying amounts, and so we thought it was very successful. All of a sudden, about 3 weeks ago, 3M, the defendant in the case, took all of its liabilities and threw them into one of the subsidiary defendants, and then took that defendant. They went to bankruptcy court and they filed for bankruptcy, and that stopped the entire litigation in its tracks. And so now the bankruptcy process now has to play out so they can find out whether or not we can separate that bankruptcy portion, or whether the whole case needs to stop and go through a bankruptcy process. You know, they put aside $1 billion for 220,000 claims. And it sounds like a lot of money, but if you do the math, it's only about $4,600 a person. If you divide $1 billion by 220,000 claims. So that's pretty horrific for plaintiffs, and they're trying to do whatever they can to avoid liability, which is what defendants do. And we're seeing this more and more often now. This is the third case that we've seen just in the recent past where pharmaceutical companies and medical device companies are filing for bankruptcy to try to avoid paying their debts and avoid having to account for their actions before juries. Now, thankfully, 3M has money. They're not filing for bankruptcy. They just tried to take all their liabilities and stuff them into one of the early manufacturers of the 3M earplugs that would therefore stop the entire litigation. So that maneuvering is brand new, and they're just doing that right now. And there's a lot of briefing going on there. But here in the Camp Lejeune cases, we're talking about the U.S. government. And unless the U.S. government goes bankrupt, there will be enough money to pay these claims. Now, how much is that going to be? We have no idea. It just depends what makes sense and what the experts have to say and what claims are ultimately permitted. I mean, the U.S. government can go on and try claims forever, or they can settle them for a reasonable amount. But we are years and years away from even talking about values.
Okay, so wow, yeah, no, I didn't. I'd heard about 3M doing the bankruptcy shell game. I guess they took the Purdue Pharma playbook, right?
Exactly.
So, and for the listeners,
Yeah.
Purdue Pharma, inventor, manufacturer of OxyContin, got lots of people hooked, lots of people killed, lots of people just bad stuff, and across the country there were judgments coming in and against them because of their truly reprehensible conduct. And one day they just go, "Yep, sorry, can't pay that. We're going to go bankrupt." And I believe that in the bankruptcy process, to really shorten it up, some judges said, "Yeah, not so fast," and did some unwinding. But again, that's a process that is not fast.
It's not. It's not.
not
And it's on a
fast.
grid, and you get paid pennies on the dollar. Right now, Johnson & Johnson is trying the same thing with their ovarian cancer claims for its talc products for Johnson & Johnson baby powder. And, so far they've been successful on it. They've really done a job on these poor women who developed ovarian cancer from exposure from the asbestos in the talc. It's awful. But that seems to be the new playbook feature right now.
So, well, that is unfortunate. Do you think that we might ever see any kind of change in the bankruptcy law to prohibit this kind of thing? I mean, again, in as much as you can prognosticate and figure out what the heck Congress is going to do, right?
Yeah, I hear you. I don't know. I mean, usually Congress, as people know, are not particularly friendly to consumers. I mean, even the Camp Lejeune Justice Act was voted down the first time, and when veterans can't get a fair shot before Congress for health care, that things are tough. And Jon Stewart and a lot of other activists were loud. Thankfully, we're able to turn the tide. But Andy, it's not easy. It's not easy getting laws changed in favor of consumers. It's a tough road, and we all know that.
Hmm. Yeah, certainly. I mean, that's the truth. Um, it looked like when the PAC Act, honoring our PACT Act, was coming up through Congress over the last couple months. This looked like a no brainer, bipartisan, easy win.
Right, right.
Um, you know, and then all of a sudden the rug got pulled out, and it looked like it wasn't happening. So um, I think thankfully enough people said, wait a minute, this makes no sense. But um, no, that is really good. That is really good stuff. And I think you make a good point. Veterans can't get a fair shake at this, then who can? And that actually kind of leads us to my segment, the tongue in cheek speaking as a veteran. Now, Rob, we spoke beforehand, and you come from a military family, but you've also represented a number of veterans. So for your speaking as a veteran, it's going to be speaking as someone who represents veterans. I want to give you the soapbox to share your opinion as someone who represents veterans. What is it that you would want our listeners and our audience to know?
Uh, First of all, I'd be remiss not to say, to the extent you are a veteran and listening, thank you for your service. I can't say that with enough heartfelt thanks. My dad was a veteran. He was he was a medic in Korea, and he passed away recently. And when he did, he had been just working for the Uniformed Services University of the Health Sciences, USIS, in Bethesda, Maryland. Where he was a research scientist, and USIS actually put a plaque up honoring my dad after his passing, for his 60 plus years of work on behalf of veterans, and for his work in the scientific community. So that was a real honor. It From the very beginning of my practice, I started representing people who received blood and blood products from and got HIV, or then it was known as HTLV3 in the mid 80s, AIDS, from blood and blood products. And that's how I started my practice. And I represented a lot of veterans who would get blood for part of their field work. Throughout the years, I've had Federal Tort Claims Act. In fact, we have a Federal Tort Claim Act trial coming up in October, representing a military family whose baby was hurt in an unfortunate situation. So it's something that I've been doing my entire career, and something that is meaningful to me. This is a real opportunity. I mean, normally in life, you don't get a chance to stand up and say, I'm mad as hell and not going to take it anymore. And Congress has given us that opportunity here. And I think we should run with it. And we should have veterans stand up and say, I'm mad as hell and not going to take it anymore. And I've spoken to families, children, spouses, veterans themselves, all who have been, wildly hurt by their exposures to toxins. And this is an opportunity for us to stand up. And I hope people take advantage of that opportunity. And certainly, if they don't, I get it. Litigation's hard, and it's tiring, and it's stressful. But hopefully, if you hire the right team of lawyers, then you can go forward and with confidence that your claim is being handled appropriately, and somebody's going to do right by you.
Rob, that is really heartfelt. I take that quite seriously, and part of the reason I think that what we want to do, as I don't do as much plaintiffs litigation as I used to, but as a plaintiffs attorney, we hope that our work makes a change, and we can maybe influence behavior. And we just saw recently out in Hawaii the Red Hill fuel farm leaking into drinking water, and it almost feels like folks haven't learned a lesson. And maybe we can. Maybe with the news of these cases going forward, and results on behalf of veterans. Not just will that bring some compensation. I mean, you can't give somebody their life back, but it brings some compensation. But also, every time one of these judgments or verdicts or settlements comes out, it's a reminder to everybody else that you got to do the right thing. You can't hurt people.
Right.
So,
And look, that's the bottom line, right? I mean, bad things happen. You have to learn from your mistakes, but hopefully, through litigation, people understand that we're standing up and drawing a line with an intent to making a place safer, if not for what we had to go through for the next person. And that's why we do what we do, Andy. That's why we do it. Make places safer.
well, I am glad that there are attorneys like you out there who are doing this stuff. I would go nuts if my schedule was constantly being controlled by courts all over the country. But there's a real sense of justice in what you do ultimately, and there's plenty of pejoratives and jokes about lawyers and ambulance chasers, but these were real bad things that happened, and I'm glad that you and other attorneys who are handling these cases are standing up for them. Is there anything else you'd like to tell the listeners?
I would just like to say that there are, like I said before, there's an opportunity to right a wrong, not only for yourself but for others going forward. If you have questions, you certainly can call me at my office at 410-413-2155, or email me directly at rjenner, RJENNER, at jennerlawfirm.com. I'll pick up the phone. I'll respond to you individually, and we can chat about what's the best way for anybody to go forward.
Awesome. And we'll put that in the show notes and in the description when the replay posts to YouTube, so you can reach out if you may think that this that you were impacted by this, or you just have questions about what this means for you.
Sure.
Anyway, Rob, I really appreciate you taking now almost 40 minutes of your time to talk to me when I'm sure you have clients to talk to, and hopefully some folks will be in touch, and hopefully this will lead to some justice.
Great. Well, I appreciate it. Thanks for the opportunity to chat with you, Andy. It's always fun.
Great. All right. Well, awesome. If you have any questions, or if you want to come on the show yourself, this is to the listeners, by the way, since Rob's already here on the show, shoot us an email. The email will be in the description. We love talking to veterans. Again, I joke, this is my excuse to talk to interesting people doing interesting things in the veteran space. We'd love to hear from you. Until then, be safe and take care.
Okay. Thank you, everybody. Thank you, Andy.